Hey, Brian Parker here, attorney Brian Parker, your old buddy. I gotta laugh because this one is gonna be a tough one, man. This is gonna be a slog. This is mainly for attorneys. And I say that knowing that not many attorneys watch my membership site. I've created a section for them. And the reason why I say it's maybe just for attorneys, but probably isn't, is the thing I'm going to tell you is something that's rarely mentioned outside of court, especially federal court, and it's really not in somebody's purview, even when you I've practiced in federal court for over 30 years. I probably practice more in federal court. I like the congeniality of it. If it says it starts at 8, it starts at 8. It's very cordial. There's a little element of fear. The judge, is there for life, and he's being vetted. So he or she is going to rule based upon the law, and he's not looking to make anybody happy or sad. He's just going to focus on his job. He or she is going to focus on her job. And federal court is just, when you're in federal court, it's everything that you think it is. You remember you're an attorney. And the judiciary is really the bedrock of the United States and upholding the Constitution. Blah, 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 blah. I've made it boring already. So how does it get even more boring? Today, we're going to be examining Federal Rule 11, motions for sanctions. So it's something to fear, but not really, because you'd never do much in your career unless you're just kind of wacky or crazy or just don't follow the rules. You're not going to see Rule 11 sanctions. It's so rarely given or moved for, and rarely granted unless there's some extreme, horrible, harassing behavior on the person against whom the Rule 11 sanctions is being filed against. It really is something, ironically, that someone that is filing it uses to harass and stir up trouble in cases where they don't like being sued, or maybe they've been sued by me too many times. And it may be something, again, ironically, where a Rule 11 sanction is, I believe, the person filing it is somewhat harassing, because there's rarely a good reason. I've never had one filed against me until now. I have this great case, federal case. It was initially a state court case where my client was sued in the wrong jurisdiction because he didn't live at the place that they sued him at. And indeed, the company that sued him, Timothy Baxter and Associates, and their attorney, Bradley Johnson, they received word from their own process server that my client didn't live there. So of course they did the right thing and walked. No, they didn't. They went ahead and served that place anyway, even though the resident owner of the place said, I've never heard of that person. And then they got a judgment against him. Of course, my client doesn't know this is going on. And then they garnished his bank account. And that's when he first learned that he had been sued. I've done a case on this as far as Article 3 standing. Here it is. How to sue in federal court. Here it is. That's the case I'm talking about today. It's going on. We had a Rule 11 sanctions motion filed against us. So it's quite serious, but when you learn about it, it's quite not serious, because you've got to do some really bad stuff if you're the guy being subject to the motion for them to win that motion. And essentially, you've got to show you brought the case, your case, my case, in error, and you didn't do any due diligence. You objectively, you should never have brought the case. And you've got to be kind of a rude person to have filed this particular lawsuit that now they're trying to sanction you with. So a Rule of 11 sanction, I'll read the rule, I'm sorry. Essentially comes down to, you have to, when you sign a document, whether you're a party or a litigator, that to the best of the signer's knowledge, information, and belief formed after reasonable inquiry, it is well grounded in fact and is warranted by existing law or good faith argument for the extension, modification, or reversal of existing law. That just means you're going against what the law says, but you've shown good faith as to why you believe that law should be turned around, and that it is not, you're not suing or filing a document for any improper purpose to harass, to cause unnecessary delay, or needless increase in the cost of litigation. If a pleading, motion, or other paper is signed in violation of this rule, the court, upon represented party or both, an appropriate sanction which may include an order to pay to the other party or parties the amount of reasonable expenses incurred because you filed this really bad or harassing motion, paper, or complaint. So Cindy put that up, and I just, in other words, Rule 11 imposes a duty on attorneys to certify they've conducted a reasonable inquiry and determined that the papers filed with the court are well-grounded in fact. So the facts I just presented to you in the state court case, they kept pursuing my client, so he didn't know what was going on, so he spent days at court pulling out all the files and found out that he'd been sued in a place he never was residing at, but for a couple of years, maybe 3 years ago. But his license always remained the same, which was his parents' license. And indeed, they had the loan application that they sued him based upon and attached to the lawsuit that showed his real address. So there was no reason to sue him. They took all his money. When he contacted this Bradley Johnson and said, "What are you doing? And I don't live there," Johnson did the right thing, and this way I'm not joking, and stopped the garnishment. But he refused to set aside the judgment. I mean, if he's stopping the garnishment, why is he not setting aside the judgment? They're two different animals, but clearly something's wrong. Why would you pull back on the garnishment? And so now the guy has to hire me, and I got the court to agree that this judgment was wrong, and the court set it aside. So I've got a court's blessing that they filed it improperly against due process. And so after the case was over in the state court, and you're going to see a funny thing, I actually bragged about how we did this great work for this client, who, by the way, is very appreciative. And they used my bragging on my videos or podcasts in the motion. This is how funny this is going to get. So you've got to be serious about this motion because it's a very serious motion. And you're probably not going to lose it. You're not going to have sanctions held against you. And you did something really bad that wasn't based on foundation of fact. And you can see from what I just told you that the facts are pretty solid, that they went against all their own process server, the judge saying, yeah, you should set this aside. This is bad. And they're still filing a Rule Motion 11 against my client. The question is when to file a motion for Rule 11 sanctions. There's important what I'm telling you. The Supreme Court has weighed in on this and has said, it is anticipated that the case of pleadings, the sanctions issue under 11, normally will be determined at the end of the case, at the end of litigation, and in case of motions at the time when the motion is decided or shortly thereafter. Motions at the time or shortly thereafter are dispositive motions. I told you this is going to be boring. So when you first file a lawsuit in federal court, more than likely you're going to have somebody, instead of answering the lawsuit, will file a motion for summary disposition or even summary judgment. I've had 3 in this one case before we even got started. And by the way, I got to put that opinion out because the third one, the court just said, "What are you doing?" to the defendant. You shouldn't be doing this. I should have filed my own Rule 11, but it's just not within me to do that to other attorneys. even though it's ripe. So they did this, and you bring it either at the end of the case, because the case is decided against you, you're going to bring a Rule 11. Look, the court ruled that they have no business suing me. Or at the end of a dispositive motion, meaning right after you file a lawsuit, a defendant will often say, you got no case, no claim under 12b-6, Rule 12b-6. Court, I want you to state there is no claim here, and therefore, here's like you care, here's Rule 12b-6. And that essentially says, you're filing a defense showing there's, in this, a 12b-6 is a failure to state a claim upon which relief can be granted. They didn't do that. They didn't file a more drastic Rule 56, which is really, it's a summary judgment rule saying you got nothing. It's usually done at the end of discovery. But none of that was done. They just went head on into a Rule 11 motion, which means they really have no basis to do that without the court either saying at trial, there's no case here, plaintiff, or defendant files the motion for summary disposition under Rule 12b-6 that says you got no case, plaintiff, right? So they went ahead and did it anyway, and that's fine. They did it after I filed my original complaint. They answered the lawsuit while at the same time filing the motion for sanctions against me and my client. And inside their motion, the funny thing is, they wrote at the end, and this is where they made a big mistake. Defendants respectfully request this honorable court sanction plaintiff, my client, and plaintiff's attorney, me, pursuant to Rule 11, including dismissal of the lawsuit without prejudice. Well, that is an emotion where you're seeking the end of the case. That motion is filed at the end of the case. So what happens is, if you file a lawsuit and someone files a motion for summary judgment or a motion to dismiss on 12b-6, it's a free shot. I try to take a very positive approach, and I go, I'll read their motion against me, and if they're right in some of the things, maybe I missed a comma or I should have made a claim stronger, the court allows you upon that motion, I think it's in 21 days, to amend your complaint. So because they wrote the words dismissal, I'm allowed to assume that that motion, it turned itself into a 12b-6 motion, at least what they're seeking. And they even put in the motion things about Article 3 standing. Here's the video again on Article 3 standing. Check it out. I bored the hell out of you in that one. I think this is an all-time boredom low. And the court and the rules allow you to amend your lawsuit, which perhaps you maybe didn't have that right, but now you get 3 days to take a look. So that irked them. They said, you have no right to do that. It's beyond the 21 days. But because they asked for a dismissal in a motion, Rule 11, which is not a Rule 12, I have a right to amend. Cindy put up Rule 15 amendment, and it says, if the pleading is one to which a responsive pleading is required, you got 21 days after the service of responsive pleading, or 21 days after the service of a motion under 12b-6. I called the court. I said they're asking for dismissal. This is a 12b-6. The court agreed. I filed the amended complaint. So the amended complaint that they're mad about has all new claims and a whole new count. Because after they did all this, knowing they had the wrong address, they put it on the guy's credit report. So I included that in the amended complaint. And under Rule 15C, this is, everybody's like, click, dislike, click, cancel my subscription. Oh, by the way, like, love, and subscribe. Cindy put something up there. A Rule 15 amendment allows a relation back. What is that? Relation back means here's the original complaint, here's the new complaint. It jumps up in the air, and here we go. You love this word. It's plunking Parker Day. It plunks onto the original lawsuit, and now the original lawsuit is gone and the new lawsuit, it's as though the new lawsuit filed months later was filed the first time. So in other words, they've charged me with Rule 11 sanction motions against a complaint that has essentially disappeared now. So they have a right, they should, after I file my amended lawsuit, the right thing to do is to either file a motion saying, hey, this case is a piece of crap, Rule 12b-6, or file an answer, or renew their motion for sanctions based upon the new lawsuit which exists, because the old one doesn't. So that's what they did. They did the row. No, they didn't. They stuck with the original motion, which is based upon a complaint that, hey, look at this, it doesn't even exist. This is what's going on with these people. What happens is you catch somebody with their hand in the cookie jar way deep, that there's chocolate way up their wrist. Their only measure now is to start doing mean things to you, right? That's essentially how this, in my opinion, this attorney operates. So in his motion, and here's how it gets weird and wacky. The courts in Michigan federal basically say, if defendant has failed, however, to move for a relief under 12b-6-1 or 12b-1 or 12b-6, his motion is for Rule 11 sanctions is way early and premature and improper. And this is, I'll put this little block up for you because I know you don't care. I'm messing with you now. You should file a Rule 11 motion against me for boring the hell out of you. Shazam. And that's the Jayola case and an even better case, the Dobrinsky case, essentially saying where defendant claims that institutional lawsuit was improper, which is what a Rule 11 sanction is, a determination as to propriety of a Rule 11 sanctions cannot be made until the conclusion of the case. Remember, that's what the Supreme Court said. You've got to wait to the end of the case or the end of the case by motion. This stuff might be adding up because it's starting to make sense to me now. So we filed that. Their motion, we filed the amended complaint, taking away really the basis of their Rule 11 motion. And I responded saying that. I didn't really touch upon the meat of their motion. And on my website with this video will be a lot of coffee. No, just kidding. Will be the word response, will be their motion, and there'll be the amended complaint. I'll throw that in for you. God, I keep scratching my nose. I'm sorry. And that'll be in Word for you to use if you have to. Again, if you face a Rule 11 motion, it may be somewhat helpful under these facts. But in their motion, here's where it gets weird and wacky. In their motion for Rule 11 sanctions, so they're supposed to say, essentially, I filed an objectively unreasonable filing, not based in fact or law, and objectively, not subjectively, I should not have done that when faced with clear proof and evidence that I would not win. So that's not the case. I focused tiny bit on that, but I said, this is BS. They are seeking, and they were seeking all this information that you only find in 12b1 motion, 12b6s. That's the only time you're going to hear something about Article 3 standing. Again, remember that video on Article 3 standing, federal court video I did? That's the third time. That requires you file a 12b6 or a summary judgment, and you make certain allegations, if you will. They did that. They talked about Article 3 standing, but they did not cite 12b1 or 12b6 or 56 in their motion. So they had their cake and eat it too, and then asked for the case to be dismissed, which you can't, it isn't part of a 1211 motion. So, because it's at the end of the case, that's why, in case anybody's asking. A motion like that is filed at the end of the case. They filed at the very beginning. So here's the laughable thing they wrote. I'm going to put it up. Cindy, put up plaintiff's counsel stated during the episode of his podcast. I'm the plaintiff's counsel. Shazam, defendants in federal court based on this venue issue. 30% of the cases that you see are 30% of the cases are a bad venue. He's quoting me. So now, because of what they did, I'm talking about Baxter, you have $1,000 for your client, attorney fees and costs. And that's an analysis of this real case. I'm going to follow up this case where I've done a counterclaim and answer. I'm going to file a federal lawsuit against the law firm. They need to be smacked around a couple of times. Meaning, obviously, I wasn't going to go to the office and start, like in the Marx Brothers, smacking people around. Nobody interprets that. Then that is a quote from Law and Lawyering Unplugged, How to Analyze a Case. They then put in the motion, however, in plaintiff's attorney's podcast, he spoke extensively about the facts of this case and bragged about how he got plaintiff his money back in a week. I got this judgment, snap, I'm doing what he says, overturned like that. Garnishment, back, gone. Money, all in the same week. Not that I'm any great CA, because I'm not. I just read, and that is true. I just read the rules, and that was Law and Lawyering Unplugged, How to Analyze a Case. So I'm telling you that for a reason. So I have a right to depose the parties involved in this case. Bradley Johnson, the guy that filed all the state cases, and let me put up what he signed. Cindy, put up the, it starts with 3, I request this court order service by alternate means. Shazam. So he put up, and here's his court officer saying, I spoke with a female occupant in her 30s who claimed that this is the Underwood residence, and she's never heard of this person. And he signs that. That's his squig. He went ahead and filed the judgment and the case and the service and sued my client and took his money, even though the people that lived at the place he served say, who the hell is that guy? He doesn't live here, and my client didn't. So that's a bad guy, right? Against all evidence. Shouldn't I file a Rule 11 sanction against him? Because there's the evidence he was doing the wrong thing, and he filed it with the court telling him this. I don't know what's in his head. Bradley Johnson says, I watch a lot of your videos. He represents Velocity a lot. I named him personally in the amended complaint. I have a right to depose him. He actually agreed to this. He was acting like he's brave and with a amount of bravado. He goes, come on, let's do it. And he's really wanted me to depose him. He doesn't want that. So I informed him, I'm putting his video on my membership website for you all. He calls you followers. Anyway, he mocks you in emails. Anyway, he is now complaining about me wanting to put his deposition on the membership website. Remember, he's quoting from my membership website and podcasts and watches them religiously. He'll call me and go, you said this, you shouldn't do it. You can tell he's probably subscribed. Let me take this moment to say, like, love, and subscribe, and try to stay awake. I'm going to show you the fun thing that happened at the end. As a gift for getting through this nonsense, I'm going to show you some fun attorney emails, all right? I've informed him again that he's going to be deposed, which he's got no problem with, but I'm going to put it on my membership website. I like to teach my, as he calls them, followers, all about how to do things. That's what my life and website are all about. So now he's crying a river, and first he says to me, this is the fun part. He says I can't do it. And I'm laughing because it's true. Okay. Also, with your violent threats towards me, I would prefer the deposition not be in video and broadcast for your, and he calls you guys followers, right? Like it's a cult or something. He's always digging like that. I don't know what my violent threats would have to do with whether he's on camera or not, but if I knew someone was going to hit me, I'd want it on camera. He has no, I don't hit anybody. I don't know if I've ever hit anybody in my life. I know a lot of martial arts. I've already said that, and I can handle myself pretty well, but I've had my ass beaten pretty good too. But I don't like to hurt anybody. It's just not me, man. I don't even own a gun. although I will soon. Not for this. Anyway, I got to shut up. So anyway, and then he says, oh, I also guess I have to say this. You're going to be hearing my voice a lot during the deposition. Please don't punch me in the face like you said you want to. So let's go back to see where I said I wanted to punch him in the face. And let's put it up. Cindy, Shazam. I'm going to follow up in this case where I've done a counterclaim and answer. I'm going to file a federal lawsuit against the law firm. They need to be smacked around a couple of times. So this, I guess, is a Groucho Marx or the Marx Brothers thing. I don't punch anybody in the nose, and I did not say specifically I'm punching anybody in the nose, nor would I. I'd lose my license. I worked too hard for this. But what he's doing is he's trying to develop a record so he can go to the court. Hey, he said he's going to punch me in the nose. By the time he gets to court, if he does anything with it, it'll be, he took out a hit on me, he blew up my house. So when I laughed at him when he said that, and I'll tell you exactly what I said, it will be on video, as is my right. But suddenly you fear for your life. It's a deposition. If I had threatened you or your fears were justified, you would want it on video. I don't understand your thinking. If it is going to be in person and on video as I'm allowed, that's what the court rules say I can do. Just waiting to hear back from my court reporting service. So he realizes he's quick, he's easy to mess with in that he comes up with these crazy ideas. You go, hey, that's not really sane. And then he'll come back with something like this, as though he's in charge of the whole thing. Okay, you can put it on video. I don't know why you'd want to do that, but please don't broadcast it to your followers. As I'm sure you can imagine, I've received repeated threats from debtors. One said he was going to kill me and my family, and don't want my face on video to be broadcast to your debtor followers. All right, thank you. Now he's asking me, and he called me and said, how about a professional courtesy? I don't know if he gave my client a professional courtesy when, against all evidence, he sued him and took all his money, even though the person that lived at the house he served said, I don't know this guy, I live here. It was a lady too, so, and my client's not a lady. So I wrote, let me put it up, Shazam. Bradley, you might remember we discussed this at length in Detroit. You had no problem with your deposition. Please reread your emails and look at their horrible tone. You are now asking for sympathy. And the reason I say that is because he'll just go crazy on me. And then I'll say, hey, maybe you shouldn't do that. And here's why. And I'll go, hey, buddy. He'll suddenly be my friend. It's quite weird having to deal with someone like that. So how you deal with him is we often have to block his phone calls and emails. So if he sends an email, it just goes into junk. It's that bad. I wasn't going to put some of the really bad stuff he writes to us up. I may in another video, but I got a heart. So I try to stay calm with him and not engage. So we just block. We don't let him call. He has to either call us, or I don't think he's going to go crazy. We let him fax. So you're now asking for sympathy. I'm sorry your actions, just look at your own emails and similar emails where you go off the rails and make personal attacks of me as evidence, have subject your family to threats. It isn't anybody that's subjecting to threats, but his own actions. That is not good and wrong on all levels. I hope you don't mind my alerting you to the irony of your pushing back on my right to use my videos on my membership after you just used my videos in a Rule 11 sanctions motion. That's filing a Rule 11 sanctions motion. You just don't do it unless it's really justified. And he used a video of a podcast. So clearly, and you've heard the facts. A new area of law perhaps would be good for you if that is really happening to your family. Self-examination helps too. It helps me. You are very capable and can litigate in your field. You run a legal office and you can manage people. So you got to be nice to people like this. You can't engage and be jerky to them. So do you have a court rule that says I cannot use the video? I have contacted the ethics bar on this specific issue, and they said it's between me and my client because it's his attorney-client privilege if he wants his case discussed. Got nothing to do with him. And it's not a criminal case of any substance. If you have had rules that I've missed, please advise. Never heard back from him again. Yet once you confront him with the truth, he runs away and probably is crazy with somebody else. I'm not sure if he's narcissist, but there's something going on there. As I said, I'm not sure he's that. He probably isn't. I'm just telling you, from my vast experience of getting emails and weird calls and craziness, that you can eventually talk him off the ledge. And that motion, when you read it, is how he operates with us. So we have to block him a lot and not let him write emails to us. That's what you have to do. So this guy is going after my client, taking his money, all based on his own knowledge. And now that he's doing the wrong thing, he's doing probably things like that to others. Of course, you do not wish him or his family harm, but the internet, I can go there, find his picture, find his address, find what he's up to, I just went online and found a whole bunch of stuff about him, just like anybody can find about me. Nothing in that deposition will reveal anything about him that people don't already know. But I will do things like not ask his address or anything personal, because it's just the right thing to do. It's a rule I follow. This person can be as crazy or bad or whatever they are. I don't have to change. So I'm just going to do the right thing. But that thing's going on my membership site for my followers, for the education and instruction of it all. It's going to go in a special law section of my membership site. I'll also put it on the section for regular folks. So this is the type of stuff that goes on in the law world. Having a Rule 11 motion filed against you and your client is extreme, but it all has a process. It should be at the end of the case, because the case will tell you. If I had filed a bad case and they got the thing dismissed because of just I had no case, then you file your Rule 11 sanctions, just as a matter of course, because you've got all this evidence showing what a bad case it is. For example, in my case, a judge ruled that these guys, Baxter and Johnson, their client, didn't bring a proper default, and there was reason enough to set aside the default. And that's evidence, of course, that I've got a great case. Why would a judge say anything else? And by the way, as you've seen in my videos, defaults aren't easily set aside. Judges, when it's default judgment, judge doesn't have to deal with it anymore. So I had to have a pretty good case or lack of due process on their side for that thing to be set aside. So for that reason and many facts, I'm fine. And now I'm doing this. I should have filed a Rule 11 sanction against me, but I got this heart that beats and gives people a chance all the time, usually to my own detriment. I'm rambling. I'm sorry. So that's your Rule 11 instruction and education, combined with the Rule 15 right to amend the relation back doctrine, which allows the new filing to be actually the old filing. By the way, that's done, by the way, if you filed it just within the statute of limitations and you want to file amended complaint, but it's outside the statute of limitations, so you can't bring it, it's time barred. The relation back rule allows you to drop right into the original rule, original filing, so you've met the statute of limitations. But again, you have to follow the rules, which is you can only do this 21 days after service of a responsive pleading or after a motion to under Rule B6, where it looks like Baxter filed in error when they asked for dispositive sanctions and dismissal, making it essentially a Rule B6, but they didn't cite Rule B6. So the case law in Michigan is, hey man, bring the Rule B6 first, then we can talk about sanctions. And they ignored all that. So you'll see my response in Word you can use attached to this video on the membership site, collectionstoppersolutions.com. You'll see their motion. You'll see my amended complaint. You'll also see the original complaint. I'll put that on there so you can see the difference. And I hope that didn't bore the hell out of you. I'm kind of sleepy now. Thank you very much. Like, love, and subscribe. I hope I've still got some followers left. Bye now. Be good. Thank you. But you know what? I'll put these emails this guy did up for a laugh. Thank you very much. Have a good one. Bye.